talking about reading the tea leaves. He had perfect timing, right at the 30-minute mark. So thank you, James Elliott of Spillman, Thomas, and Battle. Next, this is the last session of the morning, and I think it's probably the most practical and maybe necessary information you're going to have. So for those of you who are producers out there, I think you'll find this worthwhile sticking around for. Our next two... Sorry about that. All right, we're back on. Our next two speakers are going to talk about how to manage your emergencies. And I think that's a very important topic. I'm going to ask up to the stage Ben Pefferly and Judd Sheaf. Ben is a partner at Hahn Loger's Columbus office and is a co-leader of the firm's Natural Resources and Emergency Services team. He focuses his practice on environmental and energy law and facility security, easy for me to say, in emergency response. Ben's experience is broad-based. He has litigation and business clients that range from individuals and small businesses up to very large major corporations. Judd is a partner also in Hahn Loger's Columbus office and has almost 30 years of extensive experience in civil litigation, including trial and appellate work. He handles complex commercial litigation matters, including construction, antitrust, oil and gas, unfair competition, patent and copyright, trade secrets, and land use disputes. So with that, I'm going to hand it over to these gentlemen.
Better? Okay. Are you ready? Okay. It's 3 o'clock in the morning. You all remember the commercial, and that infamous phone call comes. Or you're sitting there right now, and the phone goes off in your coat, your pocket, it starts buzzing. And in that minute, in that second, your life completely changes because it's the call. It's the call, if you're in construction, that the bridge has fallen over I-71 and killed 2 people and taken out 3 cars. It's the call that your oil well, your gas well is coming in and it blew out and there's oil going into a wetlands and the people from the EPA are not too happy about it. It's the call that your truck has just been in an accident and there's very serious question about whether or not people are injured and you need to deal with it right now. Your life has just become chaos and the question is, are you ready? So what Ben and I wanted to talk about is some of our experiences have led to a framework for addressing the crises before it happens. It is by no means intended to address every situation that can come up. That's impossible. But at least you will have thought about it in advance, have a plan that at least gives you a little bit of guidance as to what you should do. And I think it's important here to say what this is not about. This is not about what you're going to hear this afternoon about federal regulations, about your emergency response, or meant to be an end-all to the training that Rhonda Rita was talking about. This is a supplement to all of that. So with that in mind, another emergency. There are 2 often conflicting issues that come up when you have that crisis moment. The first is, how do I fix this? How do I contain it? And the second is, unfortunately, the inevitable litigation that's going to arise out of whatever problem you face yourself with. Oftentimes, those are complementary issues, but too often they're not. One takes precedence over the other. And for any of you that fly airplanes or do anything like that, it's nice to have a golden rule that when all else is going to heck in a handbasket, you can count on. And the golden rule here is do the right thing. Don't worry about the litigation. Fix the problem to the best of your ability. So step one is containing the crisis. And oftentimes, containing the crisis can mean, what did I learn from the last time? Stop the crisis before it happened. You've all heard of the BP spill down in the Gulf of Mexico. What's the rule that came out for BP as a result of that? Any employee at any time can stop the drilling activities on a rig without consulting anybody or doing anything if they feel that there's a threat to health and safety. That's a good rule. But they didn't have it before, so what have we learned from past crises? Fix the problem. The other thing is, who are you going to call? I'm out here in Monroe County, I'm drilling a well, and I've got an environmental issue. Do I know who to call, or am I going to do a Google search at 3:30 in the morning trying to figure out what I'm going to do? Do you have a plan? Have you thought about all the contingencies in advance of whatever industry that you're in? And you're not going to think of them all, but it sure does a lot of good to think about as many as you can before it happens. I don't know how many of you all have seen the movie Pulp Fiction. It's one of my favorite movies, but one of my favorite part of the movie is a guy named Wolf. Wolf comes and fixes everything when there's a problem. He thinks fast, talks fast, and acts fast. Well, the only way you can do that is to have thought about your problem in advance so that you contain the problem in real time, if not prevent it beforehand because of your planning, your training, and what you have in store or ready to address because you've thought about it. Your crisis has happened. You've got to engage the experts. What does that mean? Well, back to step one, we're going to contain the problem. Who do I need out there in real time to fix whatever disaster has just befallen me? You should have thought about it. You should have people out there. You should have a list of people to call. You should have a person to call. The wolf that we try to put into our client's possession is an emergency response coordinator that is your one call that then can distribute the resources as needed in the middle of a crisis. Who is that and who are they going to call? You should know. And I said that there are two parts to any problem. The other is the potential litigation. Understand that whoever you send out to fix the problem is a witness. They are now going to be able to be deposed, called into court, and to say what they saw, when they saw it, and what they did, and sometimes what their opinion is about what they saw and how that happened. Do you have a plan to have a second set of experts or somebody that can go out and evaluate the scene that's under the context of a privilege, an attorney-client relationship that can conduct an investigation for you in a manner that's cloaked in the privacy of an attorney-client conversation so they're free to fully investigate the problem and advise you as to what happened to prepare you for litigation. And this is all at the same time that you've done what? First, get the people out there to fix it without regard to whether or not they're going to testify or not. You may get some bad news from their consulting witness. You may get the truth, which can be bad news. You can always try to find a testifying expert that has a privilege, that won't have a privilege, that can come out and render an opinion to the best that that person can. But remember, whoever you send out in real time to fix the problem is not going to have a privilege. It's going to have to say what they saw, when they saw it, and what their opinion is likely. Think about having, as part of your emergency plan protocol, knowing whatever industry you're in, a set of people or persons that can go out and on behalf of your counsel determine what happened, why it happened, and give great legal advice going forward to the litigation stage. Litigation holds. We attorneys sometimes call that the litigation within the litigation. A litigation hold is a protocol that we now must follow that requires you to preserve all the evidence in real time about what happened, any communications back and forth. So your field operators out there texting each other about what they saw, when they saw it, the communications back and forth between managers on the scene, whether it's by email or cell phone data records, the pictures that they're taking on their cell phone, the texts that they're sending their loved ones back at the house about why they're not coming home tonight. All of that needs to be maintained. And the reason it needs to be maintained is, one, it's the law. Two, it'll help you in your own internal investigation. But three, and perhaps most importantly, is the court requires it in any subsequent litigation. And you could be spot on, dead on right in regard to the position that you're taking in a court and completely lose the case because you failed to keep and preserve the evidence about what happened in real time. It's called spoliation, and if evidence goes missing that should be there, whether it's on a laptop, a text, or a cell phone or whatever, a court is completely within its power to say, you know what, as to that issue, you lose. So if that issue was who's liable, what happened on the well site, who was responsible, and it goes to information that you should have had, and somebody threw the laptop in the river, disposed of it, deleted their text, there's a very real possibility that you'll face some form of sanction from the court that you don't want to face, and you could put yourself in a position of being negatively affected even though you're completely in the right. Oftentimes when people are on the wrong side of a case, they litigate the discovery because that's all they've got. And if they find that you've destroyed evidence, you don't have it, that's where they're going. You want to preserve all the evidence. Make sure you've got a protocol in advance that all of your employees know if something happens, we're going to hold on to this evidence. You are required by our policies to maintain your evidence, collect them, and we'll tell you later what to do with it, but do not destroy it. After the crisis happens, there should be another memo sent out internally within your company reminding them of their obligation to maintain and preserve the evidence and reminding them of where it should go, and you should keep a record of that so you can show the judge, if you ever need to, that yes, we followed the requirements that we were supposed to follow in that regard. Ben?
Thanks, Judd. My name's Ben Pefferly, and I'm going to come at this from a little different perspective. Judd is your courtroom guy. I'm the guy that has the steel-toed shoes and hard hat in the trunk of his car and gets the call at inconvenient times. And it does happen. Fortunately, it happens, rarely, but it does happen. There's 4 rules that I try to come up with for emergency response, or 4 goals. One is, the goal is to manage the chaos. I can tell you from experience, when it happens very fast and very unexpected, and it quickly escalates out of control depending upon the magnitude of the incident. So your goal is to manage the chaos initially, and I'm talking about the first 4 or 5 hours. Then you move to understanding the immediate impact of what has happened. What kind of emergency action do you have to take? Is there a community issue? Is there an employee issue? So that you can, thirdly, understand the initial response. And then this is all, fourthly, with the goal towards managing your ultimate exposure. But once you've reached that point, you need to understand what has happened. It's going to be critical. And so you're going to do your internal investigation, and we've always recommended that you do your internal investigation under privilege. Why? Because if you don't do it under attorney-client privilege, your internal investigation then becomes Exhibit A in the government's or the citizen's lawsuit that may inevitably follow. You're going to do this to limit your corporate liability, your shareholder liability, and frankly, your personal liability as well. Your internal investigation has 2 components: confidentiality and accuracy. Those 2 components are absolutely critical because you have to follow the path wherever it takes you. Your internal investigation under privilege is initiated by having your counsel, your attorney, whether it be your in-house counsel or your general outside counsel, your general law firm, be retained to conduct the investigation. They may retain the experts, as Judd mentioned earlier, to retain the experts under privilege. But the attorney is going to be running the investigation. Frequently, that becomes a point of contention with management within a company, but it is critical because that is the only way you can control the privilege, that is the only way you can control the confidentiality of the report. Your attorney is going to do two things, which is going to be a little upsetting or nerve-wracking to your employees. He is going to be issuing an upjohn warning, what we call an upjohn warning to your employee. And that is he's going to be telling your employee, I represent the company. I don't represent you as an individual, but my goal here is to find out what has happened. And depending upon the nature of the event, if there's personal injury involved, if there is some sort of personal decision-making involved, the attorney is going to have to be prepared, frankly, to hire separate counsel for the employee. It creates a natural tension with your employee that if the very first word that he hears, I'm the attorney, I'm conducting a confidential investigation as to what happened, and oh, by the way, I am not your lawyer. You're entitled to have your own lawyer if you want one. I can tell you from experience that immediately creates a tense situation, and you have to walk through that very carefully. It's going to depend upon the nature of what has happened. When the investigation is completed, the report then is prepared. The reports are prepared for the use of upper management, depending upon the company structure, the company ownership or the executive management with the firm, and it's prepared for the company's counsel. Why? Because the only way you can maintain the privilege of the report is that it can only be distributed to those who who are on a need-to-know basis. If you distribute it outside this little circle, it becomes a waiver issue. You've disclosed it to a third party, and then it becomes free for the world to see. One thing I would mention to you that you have to be very careful when you're preparing your report is there's a danger of recommendations, particularly if the report writer makes a recommendation that ultimately, for whatever reason, whether it be budgetary, economic, or feasibility, makes a recommendation that is not or cannot be followed, that creates a roadmap to some significant liability issues. So when you're preparing your report, if you have one of your incidents, be very careful that it's a factual report as opposed to a recommendation report. Is there a particular button I push here? Thanks. You're inevitably going to be interfacing with government officials in the immediate after hours of your report, and it may be a local fire marshal, it may be a local EPA, it may be a Fish and Wildlife Service if you've had a release to a creek with a fish kill or something like that. You have a very real practical reality there because you as a company want to maintain your good relationship with your governmental official, and so the natural reaction is to be free and forthcoming with information, be friendly, and be willing to commit to anything. This has to be balanced against your instinct to protect the company. When you're dealing with your governmental officials in your initial response, you're going to have to be very careful about inadvertent admissions. We see this as a problem. The company representative says something, the company becomes bound to that. So you need to go through a fair amount of training to be prepared for that. Your employees, as I mentioned, have to be trained. And there are issues when you're going to say, all right, I can't use the company representative. I'm going to need to use counsel. You have to be very careful making that decision. That's generally a decision I don't recommend making unless it's an issue where you've had a significant risk of corporate or personal liability or there's been some significant injuries as a result.
You can see how in this nanosecond all of this builds, and towards the end we're going to be talking about this is why you have a plan. And one of the things that's going to happen if you're a larger company or even the local newspaper comes to you is media relations. What's the communication, if any? There should be an internal media relations protocol that you've established as part of your plan so that the message, if any, is being uniformly transmitted out to the real world. You want to be honest, you want to be caring, and you want to thought about it so you don't have conflicting reports or something that's not in the best interest of the company. I'm coming back to BP again. Remember the big blowout, and what was it that the president of the company said when he was on vacation and came back and we had all these deaths, we lost a rig, there was pollution in the Gulf of Mexico. His comment was, I would just want my life back. That's Exhibit A to the punitive damages claim. You want to be very careful about managing what you say to the media and not just speaking off the cuff. Have somebody that's the internal controller for the communications to the public, and sometimes the answer is, we're very sorry this happened, it's under investigation, and we'll report more information when we have it. But you need to be mindful that whatever you say can affect your company's reputation, but more importantly, can be used against you.
That's a very good point, Judd. Thank you. You have to be very careful of the danger of speculation. When you're involved with media relations, it's all about the 5 o'clock news. The media is operating under a deadline. They want to get a story. They're looking for sound bites. And they're going to be asking you what happened and why. And the natural inclination is to say, I think that the heat exchanger failed. I think that the control valve failed. And sometimes you forget to say I think that, but you have to be be very careful of speculating, particularly in the early hours of an incident. Really, all you know is that you want to do an investigation and a thorough investigation, and you report back to the media at a later date. So you just have to be very wary of your commitments and promises. Once you've moved past your initial reaction with the media, you're next establishing what should we do, what should we be doing to mitigate our potential liability? What is our remedial response? Do we have to engage a cleanup crew? Do we have to engage a spill response if it's an environmental release type incident? What do we need to do in order to begin to get control over the situation? I come at it from an environmental standpoint. That's my background. Kristen and I don't know how many years we've worked together or against each other, but we go back in the Wayback Machine, and we both come at it from the environmental standpoint. But it also mitigation to potential liabilities can come across from any approach, any incident. But I'm just going to focus on the environmental standpoint. I always look at my first question are there off-site impact considerations that the company needs to be managing? Is there a drinking water supply issue? Is there a particulate fallout issue? Does any testing need to be done when you're engaging in your initial response? This is one time where you may be wanting to do some close coordination with the government. It actually may be to your advantage to defer to the government, let them do the sampling. You may be taking the split samples with them, because anything you do is going to become discoverable. The reality is there is going to be testing anyways. You're not going to avoid that. But this is a good opportunity for you to coordinate with the government and build some goodwill with them. But when you're doing this, be very careful that you're not admitting liability as you're maintaining your close community relations.
Let me just add to that, Bennett. This is another good point in the middle of your crisis to think about. Are there insurance carriers you need to notify to get them involved in the problem, so that you're not creating any policy defenses down the lines, that you handled the problem in a way that they wouldn't have recommended or approved, and somehow expose you to risk of having liability problems with your carrier. Another reason to plan ahead.
What can you do on a proactive basis here, Judd? What would be your initial steps to take while you're thinking about, okay, we don't have the emergency response situation now, but what should we be doing right now?
We advise people to do an audit, of your business, and start with the kind of framework that we just discussed. Brainstorm all the possibilities that can happen, and who you would call or involve, or what you would do in any given circumstance, and have that written down in a manual somewhere in your company, again, discoverable. Have it written down in a manual. Who are we going to use? A media relations person. Who are the people we're going to call to remediate this environmental catastrophe? We know the fire departments we have to call. We know the police departments we have to call. But is that written down somewhere that's easily accessible, etc.? So,
can I give you a caveat there, Judd?
Yeah.
I had an incident a few years back which involved a release to waterways, and it was a fairly significant chemical release, and it was during some adverse weather conditions, and there was a lot of media attention. This was the type of company that was required to maintain a formal facility response plan by regulation. You know, it was a Bible. They went to the Bible, and they started going to it, and it was an, oh my God. Well, that person, because they had the contact persons, well, that person left the company 2 years ago. That person left, went through the telephone numbers. The telephone numbers for, the state and federal agencies weren't correct or had changed. And it was a situation where the company legitimately had prepared a very good, very thoughtful manual. It had gone onto the shelf where it had been forgotten for several years, and it was out of date.
And that's why we say up-to-date response plan, because you want to check it every year. Do it like you change the batteries in your smoke detector when you do the time change. Who knows what your protocol is, but once a year you ought to conduct an audit of your plan and add to it things that you've learned, delete from it things you don't need, but make sure everything's up to date.
Judd, even if you're not required to maintain a plan, can it be used as a legal defense for your company or client?
It can be. It shows that you thought about it. Matter of fact, the absence of a plan can equally be used against you if someone suggests that your folks didn't have the adequate training. We heard Rhonda talk about all the great thing OOGA is doing, and there's all kinds of training you should think about giving your employees, and beyond what's required. And so having this plan in place shows that you were thinking about it, and while it might be used against you if you don't comply with it, the fact that you have it, I say 9 times out of 10 will actually benefit you.
Okay, thanks, Judd. We are standing between you and lunch, and I've always, taken the idea that is kind of a bad position for us to be. We're available for questions and answers, either immediately now, we'll hang around afterwards, and Judd and I will be here during the day as well, and we'll be happy to answer any questions or thoughts that you may have.
Ben Pefferly and Judd Chief, I will say that was a very good presentation. I hope people listen to that because there's a lot of very good advice in there. So thank you for your insights. That concludes this morning's session. I will remind you, for those of you who have registered, the SPE Scholarship Luncheon will begin shortly in the Regent Ballroom, which is around the corner. If you haven't gotten a ticket for that, you can purchase them at the registration desk. Thank you very much for your attendance.